Hi, I'm Hilary Isacson, in-house counsel at Sutter Health in Sacramento, California, and I'm here today with Dan Hettich to talk about the reimbursement implications of the Loper Bright decision. Dan?
Hello, everyone. Nice to meet you. I'm a partner at King and Spalding, resident in Washington, D.C. Not surprisingly, I focus my practice on Medicare reimbursement litigation. So Loper Bright was obviously a big development for all agencies, but particularly within the land of Medicare, as I think we'll be discussing today.
So, Dan, how soon do you think we will see in the healthcare industry, especially as providers, an impact from this decision?
Yeah, I think we've already started to see it, Hillary. The decision that came out, I believe, was last June, or I mean, this June. So, what is that? 5 months ago or so. And as I alluded to at the opening, obviously the decision, and just to set the table for those, I think everybody's familiar with it because it was a pretty big deal. But Loper Bright overturned the Chevron doctrine, right? The doctrine that said agencies get deference in interpreting their statutes, and in particular, unless one can prove that the agency's interpretation is kind of actively unreasonable, the agency wins. So under Chevron, it wasn't the question of who has the best interpretation. It was, was the agency's interpretation reasonable? So I think, obviously it was, and long anticipated. As soon as the court granted cert for that case, it was clear that Chevron was going to be at issue. I think the general thinking was the court did not accept cert simply to rubber stamp Chevron and say everything's going fine. They were going to do something with it. So folks were watching it, obviously, when it was argued while waiting for a decision. So as soon as it came out, in my article, I mentioned that one case. It's a little bit of a sleeper issue, but an important one about the definition of patient days. And that had been briefed before Loper Bright came out, and so the government was defending its position. It was a dish case, what a patient day means for purposes of the disproportionate share payments. Um, and the government in its briefing, again, before Loper Bright, was saying our interpretation was reasonable. There was reasonable justifications. After Loper Bright came out, the judge in that case called it Loper a seismic shift and said, you guys need to redo the briefing. You argued under the Chevron standard. So already, there's no decision in that case yet, but already you can kind of see the shift, if you will. And then there was one case that I also alluded to in the top 10 article that I've been involved with, having to do with the agency's calculation of volume decrease adjustments. So this is an adjustment that so community hospitals and Medicare dependent hospitals, if they have more than a 5% decrease in inpatients from one year to the next,
Mhm.
the statute says they should be fully reimbursed for their fixed costs. Um, and I won't go into the details of the case, but suffice to say, hospitals have been challenging that issue for some time under the Chevron standard. They were losing, including in the Eighth Circuit, including in the DC District Court. And it wasn't until the DC Circuit's decision after Loper Bright came out where the court said, before we had to defer to the agency's position as long as it was reasonable, now we can employ our own judgments and statutory tools. And they decided in favor of the hospitals after several cases had gone the other way. So I think that's another example of Loper already having a significant impact. And having said all that, I do think these cases move slowly. I do think it's in this coming year, 2025, where we'll really start to see the contours of the impact of the Loper decision.
So, sort of along the same lines, do you see it opening up more opportunities for hospitals to challenge CMS action, where in the
Yeah,
past they might have just let something go?
yeah, I think certainly, even in our own assessment, when we decide what issues to bring to our clients, um, when Chevron was in place, that was obviously a big factor in our reasoning. Can we prove not only that this isn't the best, but that the agency's interpretation is actively unreasonable? It was a relatively high bar. We brought many cases, we won several, but there were cases that we said, we don't think it's the best interpretation, but we're not sure we can prove it's unreasonable. So I think going forward, yes, that analysis is going to shift. I think I mentioned in the article, not all cases have to do with questions of statutory interpretation. Sometimes the statute is ambiguous or, just tells the agency, like in the nursing and allied health, we do a lot of litigation. That's in that space. The statute doesn't have much to say. It kind of tells CMS to figure out what the provider operated criteria are.
Mhm.
So it's not going to help across the board, but there are many cases, I think, that maybe under the old paradigm would say, it's such a high burden, we might not meet it, that, now that the burden is on CMS to prove that it's the best interpretation, that folks and hospitals might be more aggressive.
Do you also see the Loper Bright decision affecting CMS from their approach to rulemaking and just generally how they relate to providers or conduct themselves, either in rulemaking or in these kinds of disputes?
Yeah, I think it will, and I think it should. I almost feel bad for CMS because for the past 40 years, they've been operating under Chevron, and when they passed a regulation or some other policy, what they had to ask themselves and what they were asking themselves is, can we defend this as reasonable? And so they enacted a whole bunch of regulations that presumably they thought could be defended under the Chevron standard as reasonable. And now all of a sudden they're told, no, actually the real standard is it the best interpretation of the statute? So I think going forward, obviously that's now going to be the test that they employ when they put forward a regulation or a policy. Can we defend this as the best interpretation of the statute? I think, we've there's been some big cases in the past couple of years on the rural floor, on different wage index issues, et cetera, that CMS has lost. I think part of what happened is with the gridlock in Congress, CMS was getting tired of waiting for legislation. And so they attempted to do some things on their own, which maybe a few years earlier they had said they needed legislation to do. And again, obviously that was under Chevron, and they still ended up losing those cases. I think CMS is going to be less aggressive in that regard, not only because they lost those cases even under the Chevron deference, but particularly now with the higher bar with Loper. I think they're going to think carefully before they take aggressive positions or aggressive interpretations of the statute.
Yeah, I've noticed that with some CMS rules, they will come out and say, we are clarifying our longstanding position.
Mm-hmm.
And whenever they say that, it actually means they're changing something.
There's
So
some significant change.
they will probably feel more constrained in terms of things like that.
Right. I will say, Hilary, I think it's, and maybe folks don't appreciate it. There's a little bit of a two-way street. I mean, for the most part, I think it's a great development for hospitals anyway. I know there's broader debates in environmental context, et cetera, about the demise of Chevron. But I think the land of Medicare reimbursement anyway, and for our hospital clients, it's a good thing. I will say, though, recently, there's been a couple of policies that CMS has adopted where it's benefited some hospitals and disadvantaged others.
Yeah.
The low wage index policy or the 340B. And in those cases, the hospitals that benefited from CMS's policy, they would like CMS to get substantial deference because they like the policy. And actually, both of those policies have been struck down. So in those limited cases, and again, most instances, CMS's policies will financially disadvantage hospitals and doesn't advantage other hospitals. It's kind of, it's a net loss for the industry, or not even a net loss, it's just a loss for the industry. But in some of these other cases, like the two I alluded to, there's winners and losers.
Here in California, we are definitely losers on the wage index, especially in Northern California.
Right. Yes, that would be something, right? You would like CMS to have gotten more deference on and the policy upheld. So there's a little bit of a two-way street going on, but I think 90%, I'd say, is favorable for hospitals.
Yeah, so we've been mostly talking about hospital reimbursement appeals, but are there other kinds of provider disputes with CMS, or I could see it with other HHS agencies like the OIG that might change in light of the Loper Bright decision?
Yeah, so I mean, my area of expertise is on the Medicare reimbursement side, so I'm most familiar with that, and the focus of my article was that. But obviously, Loper Bright itself, as I said, is far-reaching. All agencies, EPA, FDA, every one of them is affected by no longer getting Chevron deference. Within healthcare, I think anytime there's a question of statutory interpretation, and again, to be clear, that's kind of the key triggering point. There's a whole separate doctrine about the deference an agency gets interpreting its own regulation. That's the our deference, AUER. That was litigated a few years ago, and Supreme Court left it intact and just like limited the circumstances in which it would apply. That was in the Kaiser decision. So it's not all cases, but I think any case, whether it's Medicare reimbursement or, as you said, some case, sounding in other areas, Medicaid in addition to Medicare, anytime a statutory interpretation is at issue, I think Loper Bright, again, before, as long as the interpretation was reasonable, it would be valid and could be enforced, presumably. But if there's an argument that it's while reasonable, it might not be the best interpretation, I think entities in that case could bring a challenge and say, you shouldn't be enforcing this, or this isn't valid because it's not the best interpretation of what Congress said.
Are you seeing any issues that are, I would call them reimbursement or cost report type issues that affect non-hospital providers, like, anything from, home health, SNF, rural health clinic?
Yeah. So certainly, I'm not specifically involved in those, but I know historically there were many cases, very similar to, hospital reimbursement cases, where the underlying question was a statutory interpretation, whether it's enforcing, the home health or SNF requirements, et cetera, whether it was a valid interpretation of the statute. And obviously, in prior years, again, all those cases had a thumb on the scale in favor of the agency. Now, with that thumb removed, I think, equally so. Again, I'm most involved in the hospital space, and I think a lot of the, some of the bigger impacts are there, but there's no reason why it wouldn't extend equally to any other type of provider, whether, subacute or post-acute.
Mm-hmm. What kind of things are you or others in your firm telling your clients in terms of kind of like messaging, and what are the top 2 or 3 things that the business people need to know about this decision?
Yeah, so I think it's kind of two sides to that. I think one, a little bit manage expectations because, been pretty glowing, this is pretty good development for hospitals, but it's not a slam dunk. It doesn't mean, hospitals are going to win every case, far from it. As I alluded to in the article, all this does is take the thumb off the scale in favor of the agency. So the hospitals in every case still have the burden of proving that their interpretation is the best interpretation of the statute. And convincing a judge that using all the tools of, the canons of statutory interpretation, et cetera. So I think that's one important proviso, because there's some clients, okay, great, we won the issue, it's done. And no, all it did was level the playing field, which is huge because before the playing field was very unlevel, but it's not an automatic win. The second kind of related that we already alluded to is the limitations, right? There are many statutes that specifically give the agency wide discretion. Like when I don't know if the bad debt statute, for example, if it says that, I think it's the regulation that says collection efforts have to be reasonable. But if Congress used a similar word like reasonable, for example, then any reasonable interpretation of the agency would be upheld because the statute said reasonable, and so that would give the agency wide discretion. Even arguably, the agency could do what it did historically in the Chevron, which is change its position. So the statute stays the same, like they did this in the DISH context of Part C days. The statute said include days entitled to benefits in the Part A. Before 2004, CMS said Part C days aren't entitled to benefits in the Part A. After 2004, CMS said Part C days are days entitled to benefits under Part A. And they could defend each of them, and each of them could be upheld as long as each was reasonable, because again, that was the standard. So there might be multiple reasonable interpretations, and the agency under Chevron was free to kind of choose among those options. So that has gone away when Congress uses prescriptive, even if ambiguous language. But again, there are many statutes that use this broader language that does give the agency discretion. So in cases like that as well, Loper doesn't help. So I think that that's one kind of message to clients, that this isn't a panacea. It doesn't win all cases. Us Medicare reimbursement lawyers still have to do work to win. It's just levels the playing field. So that's kind of on the negative side. On the plus side, I do think the other part of the message is the more favorable one, which is that there is room now, as we discussed at the beginning of our conversation, for hospitals to be more aggressive, for lack of a better word. If CMS is taking a view of the statute that isn't consistent with, again, the best reading of the statute, there's opportunities there to bring appeals and to potentially win. So I think that sea change. I know, again, we've won many issues. We've lost some issues, and I know some hospitals can get frustrated because this goes on for 10 years and you end up losing
Yeah.
the issue. And that still might happen. I mean, as I said, we're not going to win everything, but I think, by leveling the playing field, I think more of these issues will be won. I think some of the frustrations, because the bar was so high, I had a couple of cases like that. We're clearly, I'm obviously biased, but we were clearly right. It was
Mhm.
bad interpretation stats, but we still lost because the agency got so much deference. And that's very frustrating, not just for me, but for my clients. I think that should happen less often. Hospitals should
Mhm.
get a fair shake, and be able to, have, again, not to say it over and over again, but that level playing field that we've been talking about.
Yeah, I've noticed that some here in our department and working with our reimbursement team. There are some issues where we don't agree with our MAC or we don't agree with CMS, but the effort of challenging it is greater or has been greater than the burden of just going along with whatever it is they want us to do. I mean, we've seen this a lot with GME and how much documentation we have to have, and how we organize things and what does or does not count. It's just been easier to go along with that.
Right.
But we'll see whether in the future that's going to be the decision that we continue to make.
Yeah, I mean, I can commiserate because I think the statistics were quite, and I don't have them in front of me, but it was something like the majority of cases, I think like over 2/3 of cases, I think this is in administrative law overall, and I don't think just healthcare, but courts found the statute ambiguous under the Chevron doctrine. And of those 2/3, something like over 90% would then be upheld in the agency's favor based on, the reasonableness standard.
Mhm.
So as you said, it felt like tilting at windmills. If the agency is going to win 90% of the time, because the bar is so low. I mean, it has to be actively irrational almost for the agency to lose. You end up in that situation of really meritorious claims maybe aren't being brought because, it's just not worth engaging in this, rigged game, for lack of a more polite term. So I think things will begin to shift. And again, this year will be important. We had a few months, in 2024, and as I said, we've already begun to see, the ramifications. I think this year will be important to see exactly how far-reaching this decision is.
Yeah. What are some of the cases that people should be following this year?
It's an interesting question. So I alluded to one of them that I think is Baptist Healthcare is the one that has to do with the definition of patient days
Mhm.
within DISH. Um, Obviously, there's another case, maybe beyond the scope of this conversation. The Supreme Court currently has another case, a healthcare specific case in front of it, Advocate Christ, another DISH case actually about what it means to be entitled to SSI benefits, and in particular whether or not only patients that receive cash benefits in a particular month should be
Mhm.
included, or if it's a broader category. Now, there obviously with Chevron being overturned, previously, the agency would have been able to defend its policy, its very narrow interpretation of entitled to SSI under the reasonable basis. Now they have to, show that it's the best reading. So I think that case would be important overall. I mean, anytime the Supreme Court weighs in on a Medicare
Yeah.
reimbursement issue in particular, um, we're initiating a new case challenging the 1985. Well, I hesitate. It's kind of a bigger issue. I don't know if the 30 minutes would cover it, but I'll give the nutshell version, which is that in 1985, there was a budget neutrality adjustment that was authorized by Congress. Congress said, make sure 85 payments under the inflation prospective payment system are no more than what they would have been under the reasonable cost system, which had recently been phased out. So in 85, CMS said we need to apply negative 6% adjustment to make that happen. Well, CMS left that 6% adjustment in 86 and every year forward up until today. And we thought even under the Chevron standard, there was good arguments that, that was not a reasonable interpretation of the statute. Now with the Chevron, being gone, and again, the agency now has approved that maintaining that almost 6% negative adjustment is actually the best interpretation of the statute. We feel even better about that case. Now that's hot off the press. We'll be filing a complaint probably sometime next month. So we won't have a district court decision, probably for another year or so. But again, obviously, 6% of payment is a big deal. So that was a boost in that case. And to your point, Hilary, your question before of, will it change what issues hospitals bring? We were ready to bring that case even under Chevron. But some of our clients who maybe were skeptical, how strong was the argument? I think, certainly puts additional wind in the sails. Really, one topic, and it wasn't on our list, but I think it's an interesting one, particularly for those who kind of get into this constitutional law type stuff and bigger APA questions, which is the non-delegation doctrine, right? Which, going back to law school, some folks might remember that, Congress can, again, everything the agency does goes back to congressional authorities, which is why the statute's so important. And we were discussing how sometimes Congress uses this broad language to specifically give broad discretion. So I think there's a chance that Congress will do more of that to, avoid having litigation, specific to under the Loper standard about, specific statutory terms, use broader language to say, go forth and make any reasonable, rules that you think will be efficient and, helpful to the health of the American people or something. But the non-delegation doctrine says that there's a certain minimum guidance that Congress has to give when instructing the agency, otherwise the agency is effectively acting as the legislature. So I think it'll be interesting to see if, and I think my understanding, I'm not an expert, I'm familiar with, but not an expert on all the details of it. I think historically it was a very forgiving standard. As long as it was like kind of any parameters given by Congress, court said, okay, no violation, that's good enough. It'll be interesting under the post-Chevron world to see first if Congress and particularly the agency gets more aggressive with those kind of broad mandates that again wouldn't implicate Loper. And similarly, whether the courts, particularly maybe the Supreme Court as it's currently constituted, maybe begins to tighten that and kind of limit exactly how broad a discretion Congress can give and still, clear that non-delegation hurdle. So I think that's an interesting area that's worth watching.
Yeah, I think so too. I mean, there's definitely areas I can think of, like some of the, fraud and abuse type issues that we deal with in our department, where that could be a double-edged sword because we rely on, for example, value-based Stark exceptions, which are just a creation of CMS, really. And part of, the Stark law just says CMS can make other exceptions as they see fit. And if they're not going to be able to do that anymore, that could really put a crimp in a lot of health systems operations.
Right. Yeah. And in some cases, you asked, what constituency would complain about that. I think in the example you gave, so in a lot of Medicare reimbursement, like I said, there's a couple of issues where it does pit hospital against hospital, and so there might be a constituency. Most of it, just doesn't, it hurts some hospitals, doesn't help anybody. And then there's no constituency to complain about and say, oh, this is, too broad or whatever. An example you gave, I think you're right, because I think there could be a constituency, whistleblowers come to mind that might claim, CMS didn't have the authority to or rather, by giving CMS such broad authority, or the HHS such broad authority, it runs afoul of the non-delegation doctrine and therefore is invalid. So it'd be interesting. It's Chevron, I think I alluded to, was in place since 84, I believe. Anyway, about 40 years. So it's been a long time under that kind of paradigm. It's going to be really interesting to see how the next 40 years or, even the next 4 years play out under what really is a radically different paradigm.
Well, thanks, Dan, for a very interesting conversation, and thanks to our audience. If you are interested in hearing more about these kinds of issues, I urge you to check out the RAP practice group. RAP stands for Regulation, Accreditation, and Payment, and I am the chair of that group this year. We've got a number of interesting webinars and other things planned, and of course, we are always looking for more members and more participants. So on behalf of the RAP group and AHLA, thanks again, Dan.
Thank you. I enjoyed it.